So as usual, let's begin with business and immigration law updates. This is a proud presentation of the Khurana Law Firm, where the chief attorney and counselor at law is attorney Ramesh Khurana. The moderator on this set is our other well-known attorney from Boyd's, Maryland, and that is attorney Kenneth Haber. This morning, attorney Haber questions attorney Khurana as to what is expected during site visits by the USCIS. Let's look, learn, and listen.
Welcome. My name is Kenneth Haber. I'm a former assistant United States attorney, and I'm a former senior attorney in the Office of Inspector General, the United States Department of Health and Human Services. That's the Medicare cops. And we're here today with attorney Ramesh Khurana. Welcome, Ramesh.
Thank you.
Ramesh is one of the most experienced immigration attorneys that I know, and the only one I would trust in the immigration work that I have to, and I've done that with my wife. And this is the Capitol Forum. Ramesh, welcome again.
Thank you very much. I appreciate your nice introduction.
Well, it comes from my heart, sir.
I know that. I know that.
Are you ready for some questions?
Yes, I am.
I'm glad, because I have some questions for you.
Sure.
I mean, they're not going to be easy.
That will keep my brain working.
That's right.
Yeah.
Right.
I like challenges.
Yeah, that's right. We got to get back on the road again after a long wedding that we attended.
That's the way our profession is.
That's right.
Yeah.
The question I have is concerning site inspections by the immigration authorities. What is a site visit?
Site visit by USCIS officials. You don't want to have that if you are an employer, because they usually come unannounced, and the selection of the site is based on a random basis, and just once fine morning, work is going on as usual in the employer's office, and somebody just shows up there. Oh, I'm an officer from USCIS, and I'm here to ask some questions from Mr. X.
Well, how do you know that he really is, an official from the immigration services?
I know you are an ex-cop. You would ask me that question.
Yeah, well,
Yeah.
I mean, like there could be somebody trying to impersonate somebody.
That's right. Impersonation chances are there. So you have to be upfront and ask for the identification of the person who is claiming to be an officer from USCIS.
Now, this official, is he the type of guy who has a badge, or has he just got a business card?
He would have a badge and also a business card.
Very good.
Because anybody could have a business card, right?
Yeah.
You have to spend just $20 to get your business cards and get into business.
That's right.
Right.
They
So you have to ask for the badge, and if you want to verify, call 1-800 number and do verify the validity of the badge. Sure.
That's right.
But make sure that you are only talking to the authorized officer.
That's right, and there's probably a badge number on the badge that you can correlate, so it's not a stolen badge.
Sure, that's right.
That's why they have badge numbers.
Yeah.
And aside from that, who would the site inspector, want to be speaking with and dealing with?
You know, first of all, the purpose of the site visit is to make sure that the beneficiary whose petition was approved, let us say H-1B, he's the person who is doing this job. He is available at the site unless he is on vacation. It can be because the site inspector is coming unannounced, so there is no advance notice to the employer or the employee. So he wants to know what is your salary, because for an H-1B beneficiary, now there is a specific level of wage which is to be paid as it was put forth in the immigration petition and which was approved by USCIS. So he is going to ask him, what's your salary? He says 70,000 per year. Then he has those numbers in the petition. He will make sure that he is not underpaid. Now,
will he ask to look at the books and records to make sure that the money's actually being paid?
The purpose of this visit is not to spend more than 10-15 minutes.
Oh.
You know, so he just wants to have some fairly good idea that there are no violations as regard this employer and employee are concerned. Then he has to make a recommendations based on the answers obtained to the questions, whether this would need further probe into the issues or not. So, once he has made his recommendations, either the file goes back to the shelf or there is a recommendation that we need to follow it up. Then probably the employer is going to receive a love letter from USCIS. I call it a love letter. So, basically that would have the observations of the site officials who made this visit, like whatever transpired during question answers, but it is a very brief session. So, what he can do is basically he is going to ask the beneficiary of the petition those questions. Then he would like to meet the person who signed the H-1B petition. He will say, I want to talk to you, so that he would like to see what that person has to tell, whether let us say that H-1B petition was approved for the position of an accountant, and that person is working on the front desk as a customer service representative. It especially happens in motels, hotel situation, like they are kinds of multitasker, they are doing every kind of job. But H-1B petition is approved only for this specialty occupation, and you put forth in the petition that this is for the position of accountant. So, accountant should be working like an accountant. So, he is going to test his knowledge. What do you do as part of your jobs? Oh, I keep a record of receivables, I keep a record of payables, I am responsible for the payroll, and in 5 to 10 minute conversation with both the employer and employee, he would evaluate whether it is a real job opening, a real employment, or there is something shady involved, where he is going to recommend for further probe.
Does the employee have the opportunity to refuse to answer the inspector's questions, or is that disaster spelled?
That is a disaster. If the employee refuses to answer the questions, that means what he has got to hide from the officer. He is asking simple questions like what are your job duties, how much salary you are getting, who is your employer, what is your name, what is your education. He is asking simple questions which you know by heart, not that you have to recollect that information or you have to refer to some notes. There is no need for that. If you choose not to answer your questions, you are risking the continuity of the immigration benefit. I am pretty sure he is going to write in his report, this person refused to answer my questions, and USCIS will give an opportunity which is called NOID, notice of intent to deny. They will give you a chance, explain, because that is to be given in terms of the CFR regulation, and once that notice is given, you give the answer, and based on that response you are going to see the outcome. Sometimes there could be a situation where the beneficiary of H-1B did not understand the questions from the officer. Maybe the kind of job that person was doing, like there was no English understanding requirement, and he was asking questions in English, and his English knowledge level was very poor, he did not understand the question. Then of course, we respond to the situation by preparing proper affidavits and referring to the H-1B requirement, like his English conversation skills are very poor, and because of that he did not understand the questions, but otherwise this is what person does, and you give some additional affidavits, additional evidence. If the question was about the education qualification, explain everything, and probably you can overcome that problem. But as a matter of policy or practice, no employee should refuse to answer the questions.
It's not a good idea to refuse any government agency information one way or the other, provide it, because there's a reason they're asking, and if you don't provide it, they're not going to just go away.
You are raising a very good question and making a wonderful comment. It happens at the port of entry, Ken, when people are coming from overseas visit and they are coming at the airport and they are facing the officers from the Customs and Border Protection Force. It has happened. The officer may say, I would like to check your emails. because they want to see what is the actual purpose of this person coming to the United States. Now, a person may very well say, I have to protect my privacy, I do not allow you an access to my emails. The officer would say, okay, I think you have got to go back right now by the next flight.
That could be difficult.
Because he is a visitor who is coming to the US, he is making an application for admission to the United States. They will say, we do not admit you, we put you under expedited removal and you go back.
I imagine they could even to a citizen say, we don't know that you're really the person you claim to be.
It may happen, it may happen.
That's right.
That's right.
That's right.
Yeah.
You got to at least prove who you are.
Right.
And that's even of your citizen.
Yeah.
If an H-1B employer terminates employee's employment, what sort of obligation of disclosure does he have to the Immigration Service?
Okay. Now, if you have terminated the services of any H-1B employee, of course, there are rules that you have to inform USCIS that services have been terminated, and if the H-1B employee wants to go back to his or her home country, you have to provide the air ticket and you have to basically give him a termination notice. So, if the services of an H-1B employee have been terminated in a valid manner, so you do not have any obligation to keep any record like where that person is. So, if validly terminated, you just give the evidence that this person is no longer working. Maybe that person left 3 months back when the site officer is coming to inspect, where is that person? Because there is a time lag. When you inform USCIS, it takes some time, sometimes even 4 months, 5 months to handle that kind of request of termination to put into the record. The officer does not know because records are not updated. So, you just show the evidence, no problem.
No problem. Well, whose obligation is to pay the H-1B fees and, like what are the implications about of disclosing that sort of information?
Yeah, sure. You know, when we are talking about payment of H-1B fees, now these are considered to be business expense. Now, these are required to be paid by the employer, not by the employees. There is only one exception. There is one fee which is called the premium processing fee. Under the premium processing facility, any petition which is filed will be disposed of in 15 calendar days if an additional fee of $1,225 is paid. So, that fee can be paid by the employee in the circumstance where employer says, I can wait until the petition is approved, but employee gets worried. He says, you know, I just want to get over it. I just want to see the outcome of this petition. Then that employee offers to pay for the premium processing fee. If that kind of letter exchange is there, intent is very clear that it is not because of the requirement on the part of the employer, rather this is a request coming from the employee, and then employee is allowed to pay $1,225. Otherwise, people can file their complaints with the Wage and Hour Division of the US Department of Labor, and this can be taken back, and US Department of Labor can even put some penalties on the employers.
Well, the difficulty is often with the employees is that their position is always very tenuous, so consequently there's a difference in leverage about who controls what, and sometimes the employers, I'm sure, can inappropriately leverage themselves and cause employees to pay one way or the other monies, fees that they shouldn't have to pay.
No, I agree with you. You know, like when we are talking about the H-1B employees, they are always concerned about their valid status on H-1B, because if they are fired, we discussed in one of our sessions that virtually there is no grace period for an H-1B employee, and that person goes out of status right on the day when his services are terminated. So, if the employer does not pay the wages as these are set forth in the petition, as I said, he can file a complaint with the US Department of Labor. And at that point of time, if there are no pay stubs, he wants to move to another employer, that is also possible. You remember I told in one of the sessions that whenever you have to move to another employer, that employee has to be in good status, and the good status can be proven only with the help of pay stubs. If this person does not have pay stubs because the employer is not paying, then he can explain to USCIS that I have already filed a complaint with the US Department of Labor. I am a victim of the circumstances and this should not hold against me. And USCIS, in my experience I have seen, will ignore the necessity of producing pay stubs in this kind of circumstance when you document it very well.
Very good. So as long as they document it, do they grant them the non-existent grace time to get the new employer, or are they going to be shipped out of the country anyways?
No, in fact, if they are convinced that yes, he is a victim, then of course they will consider it. I think we have got to wrap up. Time is up. So I thank you very much, Ken, for inviting me, and I really enjoyed your questions.
Well, I enjoyed posing them to you and also hearing the answers.
Always pose me questions. Thank you so much.
Thank you.
I appreciate it.